Well, good good afternoon. Just afternoon here, but obviously good morning to everybody over there in America. And hi there, Darkside and Linda. First of all, a few things before I forget. Apologies for the sound quality of yesterday's video. I did have, during the afternoon, one of my pupils had similar issues. That's when I first realized that the sound wasn't as good as normal. So I'm hoping that I've fixed that and that the sound is going to be okay. Let me just check by listening to myself again. It's going to be okay. Let me just check by listening to myself again. It's going to be okay. Let me just check by listening to myself again. Yes, as terrible as usual. Not to worry. Okay, but yeah, it's hopefully it's fine. The second thing I wanted to apologise. Not my fault. I am totally blaming the little dog. Distracting me, pattering around. I forgot in yesterday's video to screen share, so I read all the way through those articles without you having the benefit of seeing them. So I do apologize for that. That's why I put them in the description below. Now, Big Dog, you asked me some questions during the week. I immediately fired the questions that you asked to our Millbilly expert, our Andy Colburn expert, Millbilly, and so we'll hope to get his reaction, but maybe not with quite the profanities that he was able to generate towards Colburn. So anyway, yeah, we'll ask Millbilly about Colburn and his finding of the RAV and the reading of the number plate, etc., etc. Talking about Colburn, the interesting thing was that on the video, the 100 Questions by Kathleen Zellner, cartoon character, as usual, stuck her beak in, and I don't read what she writes. I just don't. I can't be bothered. It's just a waste of time. But I did notice that within a short space of time, there was 10 or 15 people had replied to her, basically pointing out, you're a coward. You're not prepared to come on and debate at all. You're a worthless piece of what's it. Just go away. And of course, she deleted her message, which deleted everybody else's. And then I noticed another comment that she said, where I must have deleted her previous message. No, I didn't delete that one. I left that one because of all the responses that she got to it. But what was really laughable, was she was talking about once Andy Colburn's civil suit is settled in his favor with Netflix, that apparently she's heard that the intention is to go after all the YouTubers. Woodpecker, that's just laughable. I've had this before with Tess Sanders saying, I've been in touch with YouTube. They're going to shut you down. The lawyers are going to be in touch. What a load of nonsense. But doesn't it show, it gives away your agenda. Your agenda is you would like to stop people talking about this case. You would want us to just go away, stop talking about the case, forget about Stephen Avery, forget about Manitowoc, forget about Brendan. You just want us to go away and stop talking about it. I can assure you, cartoon character, it ain't happening. No way. And Zelda's not going away. Of course, the thing is, what you're doing is, rather than answering the questions that Zellner has set and getting yourself $10,000, that's impossible. So all you can do is try desperately to stop people from doing YouTube channels. And do you know what? Since Erekose, since I first came across Erekose, you look at the number of people who have taken his lead and come up with their own YouTube channels. I can't remember them all. I cannot remember them all. You know, you can thank Erekose for that. He's the one. He's the one. And guess what? As I said, we're not going anywhere. We're not. We're staying right here. Anyway, hopefully the sound is okay. And this time I have got the screen sharing ready to go. So here we go with this. I should explain this article I was alerted to by Mark Godsey. So here we go. Brilliant article. Hopefully that'll work. Looking good. As I said, I always, you know me by now, I always stop for a moment just to check that everything's okay. And I did, but of course I never checked to see that the document was up on screen. So I do apologize for that, because that's poor of me. But here's the other interesting thing, right? If I've made a mistake, if I've done something wrong, I apologize for it. Are you listening, Manitowoc? I don't think they are. Anyway, so here we go. Americans' grand jury system isn't built for justice. We know, we served on one. This is by Cherie Naxon, John Philcorn, and Elaine Bayliss. November 18th, 2020. So we're the 21st today, so that would have been the Wednesday when this article came out. It's quite a long read. Here is the Cuyahoga County Justice Center and Jail. And let's go through. Just a little bit overzealous there. The recent release of tape recordings from the Breonna Taylor grand jury and public statements by 3 of the anonymous grand jury members have offered America a rare look into an opaque system. Yes, very opaque. You can hardly see anything. And that's exactly how they want it. The tape and the public statements are unique in that they concern a case of nationwide interest and a police shooting. In other ways, however, they illuminate issues common throughout the process as a whole in regular cases heard across the country every day by citizens called up through the jury pool. From what America heard and read about Breonna Taylor's case, it's painfully obvious that the grand jury played a subservient role to the will of the prosecutors, where Kentucky Attorney General David Cameron, I'm sure it's not the same David Cameron that was the former Conservative here in the UK, deflected responsibility for the unpopular outcome to the grand jury. The members themselves told quite a different story. Our country is seeing, let's see if I can go a bit bigger. There we go, yes. Our country is seeing renewed energy behind efforts to reform our justice, criminal legal system. Increased knowledge and awareness of the problems inherent in the grand jury process are critical in this examination. Grand jury reform should be part of criminal justice reform. Like all the other pieces of this giant machine, grand juries too often are tools for injustice. The general public knows very little of the grand jury process, except that it is controlled by prosecutors under a shroud of secrecy. That's a key part of the problem. Jed's American Grill looks very nice. So after 4 months of service on a Cuyahoga County Grand Jury, during which time we heard more than 1,000 cases, we want to help lift that shroud now, sharing what the public should know as conversations about reform continue. The three of us first met in May 2019. Two of us came up for selection through the regular jury pool. One of us was appointed by a common plea judge to serve as for person. Oh, to serve as foreperson. This is common practice. Much like regular little petite jury selection, the grand jury version is a bewildering process that only makes sense the further you get into it. After being selected, we were sworn in and took an oath to keep proceedings secret, which is ostensibly to protect the privacy of citizens who are being accused of crimes and also for the safety of the grand jurors themselves. We received a couple of days orientation, during which we met the two prosecutors assigned to our grand jury. The training is wholly designed by and coordinated by the prosecutors. Some aspects of training were helpful, some aspects seemed a waste of time, and no aspects came from a defense perspective. Specialized instruction, such as the dynamics of domestic violence, the use of confidential information, or the difference in the various murder charges, was extremely beneficial. Touring the casino and the morgue felt like public relations stunts. In Wisconsin, visits to the morgue are what the certain guests of Ken Kratz get to do. That's their privilege. Go on a date with Ken Kratz. He'll take you to the morgue anytime. Okay, other seemingly vital information, such as the intricacies of Ohio's gun laws, was never detailed to us, despite repeated requests. It is important to understand some context up front. The Cuyahoga County Grand Jury is a 4-month assignment of 2 full business days per week. We could write pages about how the structure fundamentally disallows this cohort from truly being a jury of one's peers for many possible defendants. There are 3 grand juries serving at a time, usually on different days. Each grand jury includes 14 members, all of whom hear every case, and 9 of whom, the first 9 chosen from the pool based on their lottery number, deliberate and vote on the charges. Each grand jury is assigned a pair of prosecutors who present the vast majority of the cases. Some cases have a special prosecutor assigned due to the severity of charges or the domain intricacies of the case. In the room with the grand jury and the prosecutor is a court stenographer. A time-intensive endeavor. The sheer volume of cases would probably shock regular citizens. With approximately 50 cases per day and 3 grand juries each serving 2 days a week, roughly 300 possible felony cases enter the system per week. In 4 months of service, our particular grand jury heard more than 1,000 cases. That's an average of 9 minutes per case. 9 minutes to hear, deliberate, and vote on each one. Okay, there are some legal standards that are important to know too. The decision to indict is based on the standard of probable cause. Did a crime probably happen? Is it more likely than not that the person accused is the person who committed that crime? We were often given the guidance that if there's a 51% chance on both factors, then we must indict. So if you've got 49% reasonable doubt, it still doesn't apply. That's interesting. Then must indict and trust that the subsequent jury trial would comb through the evidence more deeply to get to a verdict that meets the standard of beyond a reasonable doubt. So that they're agreeing. It doesn't matter. We don't need to reach reasonable doubt at this stage. In other words, the grand jury is the beginning of the process. In theory, it's the first step, the introduction of the case into the system, where a defense would follow and further evidence would be introduced that might not have been available to us. Unanswered questions would be addressed at trial. But what we didn't know, because it was omitted in our training, is that over 95% of indicted cases in Cuyahoga County never go to trial. There is no further step. The grand jury essentially and unknowingly acts as the case's only jury. We had to discover that later on our own. Most defendants plea bargain. In anticipation of this, the prosecutorial process includes the stacking of charges, which is basically a chess game tactic. An individual is charged and indicted with a laundry list of charges, so the plea bargaining process has more room for negotiation. The grand jury is in essence, is there to create prosecutorial leverage in those negotiations. When we talked with community leaders last summer, we learned about the psychology of coming to the table with charges stacked against you. Attorneys explain all of the charges and the potential maximum sentences. The total number of years is daunting. Many defendants, well, clearly 95% of defendants plea out because they worry about their odds of success at trial. Obviously, quite a lot of them will be actually guilty anyway. Fair enough, yeah. Many plea bargain because they are being held in Cuyahoga County Jail, cannot afford bail, and simply want to receive their sentence and go home or go to prison. And of course, this is the other thing. If you take the plea bargain, then you do this deal whereby you know what you're going to get. Again, it's putting pressure on people. You know, they don't have to be proven at a courtroom. Many of these people are innocent. Research has shown people who are not guilty actually plead guilty at a significant frequency. Yeah, they do. We know that. Whether because of inadequate legal representation, personal issues, or because the overwhelming prospect of facing a jury and a maximum sentence is a gamble not worth the risk. Knowing what we know now, we're left feeling devastated that we unwittingly helped to stack charges to create plea bargaining leverage. During their deliberations, grand jurors and trial jurors look closely at the definitions of charges and compare these definitions with the evidence they have received. Trial juries receive definitions of charges from and bring questions directly to the judge, an independent, neutral arbiter. Grand juries, meanwhile, receive definitions from and bring questions to the prosecutors who are actually a party to the case, the accusers. Jurors who have been trained by prosecutors, orientated to cases and processes by prosecutors, and whose workloads, seating arrangements, and bathroom lunch breaks are governed by the prosecutors, well, it is no surprise they end up deferring to prosecutors. It takes a very bold juror to resist the pressure to conform in this group context. It takes profound assertiveness to look up the Ohio Revised Code definitions on one's phone or in the 5-inch thick law book that sits on the prosecutor's table. And it takes an incredible amount of wherewithal to be the voices that slow the pace of churning out the hefty indictment docket. The expectation is to indict. There is one-sided guidance to indict. There is pressure to indict. The noise issue I had with one of my pupils was that he said it sounded like there's water, and it's just started chucking it down. So if you can hear anything, it's the wind and rain outside. Okay, a much healthier structure and organizational culture is required for a grand jury to be truly empowered to wrestle with and apply the law in every case. Some cases are simpler to decide. The evidence and charges are clear, but many cases per day bring uncertainty, relying on the idea that a trial jury will get more time to look closely. Grand jurors can easily make peace with the 51% certainty and indict someone without much evidence. In fact, I want to quickly show you something. It was something that I have come across before. Is it this one? So that's the bit that we've just read. So it's this one here. It's notable that the 51% chance. This is a quote from Darrell Massey, or to do with Darrell Massey, and of course he was the Adnan Syed investigators. I'll give you the whole lot here. Detective Darrell Massey, who has had a few of his own cases overturned because of integrity issues, participated in the series. The Adnan Syed series. His interviews project an unflappable confidence in the homicide unit's tactics, despite its legacy of wrongful convictions. Back in the 90s, Baltimore homicide was known across the country for the ability to clear cases, Massey brags in episode 1. Later, he notes that homicide detectives can safely clear a case when they have 51% confidence that the suspect under arrest is guilty of the crime. Convincing a jury to be 100% certain is up to the prosecutors. I think you can see the problem there, can't you? But here's another one. Massey is saying that, that it should be that the prosecutors have to demonstrate this 100% confidence, certainty. But the prosecutors in grand jury say, no, we don't need 51%. We don't need 100%. We only need 50%, 51%. And of course, what you've got the detectives. They come up with 51%. Okay, 51%, which means there's a 49%, chance that there's a 49% chance of reasonable date. Now, all the prosecutors are doing is presenting quickly what the police have found out, which is only 51%. So therefore, the prosecutors are actually saying you only need 51% of the 51% that the detectives have supplied us. 51% of 51% is 26.01%. Let's get back to where are we? Yes, here we are. Okay. Anyway, It says here, yes, grand jurors can easily make peace with the 51% certainty and indict someone without much evidence. Yeah, it's not 51% certainty you're dealing with, it's only 26%. We wonder whether members of the grand jury cohort would have voted the same way had they been taught that over 95% of these cases would never see a trial jury. Compounding this problem, the grand jury, acting as a de facto trial jury by way of providing prosecutorial leverage based on the 51%, which I'm saying is 26.01% framework in cases that largely never actually go to trial, is that grand juries see little of the evidence that would be presented to a trial jury. The prosecution is not required to present all the evidence it has, even exculpatory evidence that would shed doubt on the charges. To understand how evidence is presented requires an understanding of law enforcement roles. There are specialty units like financial crimes, sex crimes, child abuse and gang unit, homicide, etc., where cases are presented by officers and detectives who work the cases hands-on. These cases have been built over time and are presented with ample evidence. Those presenting are extremely familiar with the case and are thus able to answer the jurors' questions. This is not the case for regular patrol officers. Patrol officers rarely present their own cases to grand juries. There is a role within police departments called grand jury liaison. This role entails one officer presenting several cases from their department to the grand jury. While there is an admitted element of efficiency to this grouping of cases and one skilled officer presenting in a way familiar to the grand jury, this means that cases are presented by proxy. The liaison reads the police report and other evidence to the grand jury. Occasionally, we will get a printed document to review, but only for unique cases. Otherwise, it's all oral presentation. If there is a question that the file cannot answer, the liaison might come back on another day after seeking clarification. During our 4 months of service, there were times when jurors requested more evidence. Occasionally, this was honoured. More often, it was not. In some cases, our request for more information changed everything, leading to true clarity and a just indictment. In other cases, we did not get much more and were tasked with deciding based on too little information. In that regard, cases of resisting, refusing, or assaulting a police officer were particularly concerning. In a city under a constant decree due to excessive use of force, we wondered why a self-report by an officer was sufficient evidence for allegations that involve a conflict between citizen and officer. Of all the 1,000+ cases we heard that summer, we saw body cam footage exactly once. And we saw 0 body cam footage on cases of resisting, refusing, or assaulting law enforcement. Cell phone footage from incidents around the country has demonstrated that an officer's account of a citizen resisting arrest is not always what actually happened. Cuyahoga County is no exception. What was initially discomfort over this issue in the aftermath of our service became outrage in June 2020 when we read about Kenta Settles a mentally ill Garfield Heights man who was wrongfully indicted and detained for more than 4 months in the Cuyahoga County Jail on charges of felonious assault on a peace officer and obstructing official business. The grand jury that heard Mr. Settle's case was not shown the body cam footage from the incident and voted to indict based on the prosecutor's presentation. Eventually, when body cam footage was acquired by Mr. Settle's lawyer, the video showed officers beating, tasing, and mocking Mr. Settles. County prosecutor Michael O'Malley dropped the charges days after the body cam video was made public. Mr. Settles spent 4 months in jail because that video was not shown to the grand jury before they decided whether to indict or not. That case demonstrated exactly why the grand jury's focus should not be on the number of cases completed. The process should be on due process. Grand jurors should see body cam and dash cam evidence for all charges that involve a conflict between a citizen and law enforcement, e.g. resisting arrest, attempting to flee, assaulting an officer, etc. Indicting people for these charges where the sole evidence is law enforcement self-reporting, this is not justice. Likewise, camera footage should be required for any felony allegation that is based on consent, cause to search a vehicle. These vehicle searches typically begin with a traffic stop, and as we have seen in recent articles detailing statistics from our own county, University Circle, Brayton Hall, it is far too common for vehicles driven or occupied by minorities to be stopped for a small traffic infraction that becomes a felony charge because officers saw something dark under the seat, there were furtive movements, or a smell of fresh marijuana. We believe that without a requirement of video evidence of consent or cause to search, there is room for law enforcement to coerce citizens into consenting to search. As a society, we are obligated to look at the overt racism and abuse of power that is self-evident in these all too frequent cases. There is a mechanism in place for grand juries to serve as an overall check and balance to the system, in theory, as the process rolls onwards. The foreperson of each grand jury is required to write a report at the end of jury service. We decided to approach this report collaboratively as foreperson, deputy foreperson, and assistant deputy foreperson. We also decided to survey our jury so we could include their words in our report, assuming that the court and the prosecutor's office would want to improve the system. We detailed feedback about how we were trained, about laws that need legislative attention, about law enforcement and racism. I bet that went down like a house on fire. Telling them how to do their job. I bet they loved that. In the months that followed the filing of our report, we did not hear back from the administrative judge nor the prosecutor's office. This was troubling because the report detailed not only suggestions on a macro level on the topics covered thus far, but also on a micro level, i.e. how Cuyahoga County specifically could better equip future grand juries with training and how county leadership could specifically make the process safer and less stressful for citizens who are called to serve. The lack of response was even more upsetting when we dug deeper after reviewing over 50 other Cuyahoga County grand jury reports. In the 18 years of reports we have thus far reviewed, there are repeated observations, suggestions, and concerns lodged time and time again with little or no result in changes in grand jury operations. Many of the reports are far less substantive, substantive, resembling thank you notes and applauding staff. In our research, we found a period in the early 2000s when grand jury forepersons and a judge spoke out about unjust indictments for felonies based on trace amounts of crack cocaine. The practice was unjust because the charge was a misdemeanor in every Cuyahoga County municipality except Cleveland. We spoke with a researcher, a judge, and a foreperson who played key roles in the pursuit of equitable application of that law. We found a 2016 task force appointed by Ohio's Supreme Court Justice O'Connor to study grand jury operations. The task force's report included revisions of training that would have benefited us. As best we can tell, none of the grand jury task force's recommendations have been implemented. We found that over at least the past 20 years, our community has experienced resurgences in interest in true reform. Sadly, most of the recommendations sit on literal or virtual file cabinets unheeded. In addition to the report on our overall jury service, the grand jury is also charged with auditing the conditions of the Cuyahoga County Jail. This is to occur quarterly per state law. Each of the 3 juries serving during a 4-month period visits separately. It is our observation through our grand jury training and through reading countless reports of others before us that most grand jurors have not been informed that they are there to audit. The jail visit is treated like another educational tour or field trip. Because we clearly understood our duty to report back on what we saw, we took our auditing function seriously and are deeply dismayed to discover that this is an uncommon stance. We believe this is not due to neglect of duty, but to a failure of the system to properly orient each grand jury to the seriousness of the task. Not only do we not want you to report, we don't want you to know that you're supposed to report. Seeing the jail conditions is important for the body that indicts citizens, because this is where accused individuals, at least those who cannot afford bail, wait until their cases are heard by the grand jury and after indictment, when citizens might appear before a judge during a plea bargain session. The injustice of our cash bail system is blatantly obvious as one walks through the pods at the Cuyahoga County Jail, which has been the subject of a damning U.S. Marshal's report and various investigations centering on its inhumane practices and the deaths of inmates. The jail has become a de facto mental health provider for many of the poor in our county. Numerous cases came before us in which the accused was reportedly suffering from mental illness. Every time a juror asked about the most humane way to help suspects whose charges seemed to be tied to mental illness, we were assured that indicting chronically mentally ill citizens was the best way to ensure they got the help they needed. This help is supposed to be through a mental health docket, which provides specialized support and diversion services. However, that help was not evident in our jail tour, where mental health services consist of medication and crisis intervention. There must be a better way than incarceration to identify these cases and to help people who suffer from chronic mental illness. There must be a better way for all of this. We write today because we realize that the average citizen knows little about the workings of the grand jury. This is by design. As required by state law, the prosecutor's office remains a veil of secrecy over the grand jury to protect the reputation of the suspect before they have been charged. We believe that this veil is too large, covering up inefficient and dysfunctional systems that ensure disproportionate rates of incarceration of non-white citizens, of those with low income, of those with mental illness, and many times of those who may actually be innocent of the crimes they've been charged with. Grand jurors are told they are a check and balance on the prosecutor's office, yet are trained and entirely guided by the same prosecutors they are supposed to check. There is no presentation from a defense perspective in training or on cases. The only scrutiny comes from the jurors themselves, who have been trained in a quick and biased way. This means that the true check and balance is voiced individually as jurors wrestle with their consciences and educate themselves outside of the jury room. That's a tall order, and the burden should not be on them. Unfortunately, in our experience, this means that jurors unwittingly collude with a wrongful process that allows unjust indictments to occur. This means that the only way of stopping this unjust process is for individual jurors to find each other and unite their voices, and for the public, all of those potential grand jurors and those who are interested in reforming the process to better know the process. We ask for a redefining of felony laws and processes. Our prison system is overwhelmed because our society uses incarceration as the punishment for too many crimes. We need the three branches of government to take a hard look at the results of our current criminal justice system and overhaul the sentencing laws. We ask for a redefining of prosecutorial success. We, as citizens, don't want success defined as the number of indictments processed per day, week, month. We want fair indictments. This means indictments based on actual evidence and with full disclosure of the high rate of plea bargaining, as seen locally in the Kenter Settles case and nationally with the Breonna Taylor case. The grand jury system is flawed, leaving plenty of room for the perpetuation of a broken and racist system that is the gateway for mass incarceration. While we are sworn to secrecy about the proceedings, the people, places, and charges, we feel it is our duty to speak openly about the mechanics of the grand jury. We hope this paves the way for necessary reforms. I can just do that. Obviously, Cuyahoga County is in Ohio. In Ohio, that's where Mark Godsey is the founder of the Ohio Innocence Project. I've actually just finished reading the book Blind Injustice, and again, it had some interesting stuff right up to the end. So now, next task is to read Richard Leo's book. But in the meantime, whenever there's an article as interesting as that one, you can bet your life I'll be sharing it. So, to Woody, we ain't going anywhere. We're not going anywhere at all. Bizarre, stupid, idiotic, moronic, threats that they just don't wash. They never have done. So anyway, just quickly, hi Alice, hi Jazz. Nice to be quite prolific on the chat there. Hi, hi Linda, hi Paul. Alice, Jazz, Linda. Just Linda. Dark Side. Paul, hi there. Yes, that's everybody. Okay, thank you all once again for tuning in. We'll catch you all again soon. Hopefully, we'll be back to normal on the Monday morning for a chat with. Oh, hi, Ronald. Yes, we'll have a chat with Dr. Silkman, Millbilly, and Mark as per usual. Find out what the latest news is with Colburn's civil suit. He's then going to go after YouTubers. Are you right? Are you right? Oh dear. Not only are you a cartoon character, but I'm your quite humorous. Okay, we'll catch you all again soon. Bye for now.